Hello, everyone. Thank you for being here at the Library Book Talk. My name is Leslie Diana Jones, and I'm Associate Director of Public Services for the Law Library. On behalf of the library, I would like to welcome you to the Harvard Law School Faculty Book Talk on Constitutionalism and a Right to Effective Government. We'd like to thank the Dean's Office for sponsoring the Faculty Book Talk series, and a special thank you to the library staff who worked on making this event happen. Teresa Knapp, Debbie Ginsburg, Rachel Parker, Anna Martin, Alethea Jones, Deanna Barmakian, Lisa Ryden, and Maya Bergamasco. Before we get started, please take this time to silence your cell phones and other devices that make noise. Thank you. We're joined today by the book editors of Professors Vicki Jackson and Yasmin Dawood, and panelists David Law, Gerald Neuman, and Mark Tushnet. Professor Vicki Jackson is the Lawrence H. Tribe Professor of Constitutional Law here at the Law School. Professor Yasmin Dawood is the Professor of Law and Political Science and the Canada Research Chair at the University of Toronto. Professor David Law is the E. James Kelly Jr. Class of 1965 Research Professor of Law at the University of Virginia School of Law. Professor Gerald Neuman is the J. Sinclair Armstrong Professor of International, Foreign, and Comparative Law and the Director of the Human Rights Program here at the Law School. Professor Mark Tushnet is the William Nelson Cromwell Professor of Law and Emeritus here at the Law School, and he will be our moderator today. So we will now turn it over to the speakers for discussion, after which time we'll have time for an audience Q&A. Thank you.
Well, thank you so much, and a big thank you to the Harvard Law School Library for sponsoring the event and to the Law School for supporting the conference back in 2019 where the ideas in this book were first discussed. Thank you to my wonderful co-editor, Yasmin Dawood, for so much, including coming in from Canada for this event. Thanks to my Harvard colleagues, Mark Tushnet and Gerald Neuman, and to Professor David Law, my colleague from the University of Virginia, both for contributing to the book, wonderful chapters, and agreeing to speak today. I'm going to speak briefly about some core ideas laid out in Professor Dawood's and my introduction. To begin with, constitutions have positive purposes. The U.S. Constitution's preamble says it's about establishing justice, securing the blessings of liberty, providing for a common defense and for the general welfare. But constitutions more generally purport to establish governments for beneficent purposes. Now, what happens if government is ineffective? Without effective government, one cannot secure rights. One cannot enjoy a well-ordered life in society. And one need not have a completely ineffective or absent government to realize the importance of government itself in protecting rights and advancing people's well-being. In the U.S. tradition, the Declaration of Independence proclaimed, with sexist language modified, we hold these truths to be self-evident, that all people are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among people, deriving their just powers from the consent of the governed. So here we have yoked together rights, well-being and happiness, democratic consent, and government. Without effective government, rights cannot be secured. Conditions of material well-being cannot be secured, and representative democracy cannot be secured. But where is effective government in the discourse of constitutions and constitutionalism? It's largely absent. To be sure, there are pockets of doctrine where concerns for effectiveness turn up. So in strict scrutiny, the idea of a compelling government interest might relate to effectiveness. But in US discourse, these interests are optional. They're up to the government whether to pursue. They're not understood generally as mandatory duties of government. Professor Dawood and I argue that effective self-government should become a better theorized part of the understandings of democratic constitutionalism. We offer several possible conceptualization beyond the idea of these optional interests We ask whether effective government could be understood as a value or principle of liberal democratic constitutionalism, or as a government duty, or even as a right. As a principle, effectiveness has been both denied and embraced in US constitutional discourse. Famously, in INS against Chadha, Chief Justice Berger denied that concerns for an effective government should play any role in interpretation. Others, however, like Justice Robert Jackson in the Youngstown Steel case, have insisted that while the Constitution diffuses power the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. As mentioned before, in US doctrine, government interests are treated as optional policy choices. But if we think effectiveness is something that governments must pursue, it could instead be conceptualized as a duty of government. Now, duties can be either justiciable or non-justiciable. But even when non-justiciable, the recognition of a duty of effective government may contribute to the norms of democratic self-governance, development of which is sorely needed in this moment. Alternatively, one could argue, as Professor Law will in a moment, that people have a right to effective government, perhaps non-justiciable, that's me speaking now, but a right that is in the balance as more traditional rights claims are made. These are the kinds of questions discussed in the book. As its organization and scope suggest, questions about effectiveness in constitutional self-government are not limited to any one issue area, nor to any country or region of the world, with contributions dealing with South Africa, India, Brazil, and as well as countries in the global north. The first two sections of the book explore theories of what constitutions are for and the relationship between positive rights, effective government, and liberal democracy. Professor Dawood, Law, and Neuman each contributed to these parts. The book then turns to the role of courts in sustaining effective rights protecting government, and you'll hear from Professor Mark Tushnet about his co-authored chapter in that section. The next two parts deal with executive and administrative constitutionalism, and then legislatures, and I contributed a chapter there. The last chapter deals with the broader context for constitutional behavior and institutions, changes in politics, media, and corruption and its avoidance being an understudied but highly important part of democratic constitutionalism. We think the book contains a lot that would be of interest. We hope it will be persuasive that effectiveness in government is not something one can just assume. It must be worked on as part of the project of constitutionalism. There was much disagreement in the room by those who participated in the 2019 conference, and as you will hear, I think disagreement remains about conceptualizing the role of effectiveness in democratic constitutionalism, but to the extent that people are discussing this question at all, the book will have, at least in part, achieved its purpose. Thank you. Turning it over to Professor Law, I think, or Mark?
No, is David there? Yes, okay, so David, why don't you start?
Great, thank you so much. And I just want to say it is such a privilege and a pleasure to be part of this really innovative, important, disruptive, thought-provoking volume. I hope people will run for it, not walk, but run for it. And it's an honor to be on this panel. Sorry I couldn't join in person, but thanks for accommodating me via Zoom. It's one of the most intellectually interesting rights-related projects I can think of in a long time. I mean, this idea of right to effective governance is so rife with tensions and contradictions, but that's, and I think Professor Neuman will certainly be taking up some of those, but that's a large part, I think, of what makes the concept so important. It is disruptive. In my remarks, I just want to start briefly by touching on the practical case for right to effective government at the risk of stating the obvious, but then move on to a couple of the ways in which, excuse me, the concept is simultaneously familiar yet disruptive and potentially even transformative of traditional liberal rights talk, and could even serve as a bridge to a post-liberal vision of constitutionalism, which we could kind of use in the 21st century. So quickly, first on why might we need a right to effective government? So broadly speaking, our ability to act on the problems and threats that face us, or even to meet the challenges of everyday living, are increasingly impossible without collective effort. This is the age of interdependency and specialization. And the state is the vehicle of that collective effort. So without effective government, really, it's hard for people to operate in modern society. Hence, even the liberal tradition, with its purported celebration of supposedly absolute rights, recognizes a variety, or categorical rights, recognize a variety of situations in which the government can act decisively and at the expense of even enumerated negative rights, right? So it's accepted, for example, in the US, that governmental infringements on well-established constitutional rights can be justified by so-called compelling governmental interests in emergencies and other situations where life and limb is at stake. The language of compelling governmental interests tends to obscure what is really at stake in these cases, and namely the urgent basic needs of actual people who are depending on the government's ability to act effectively. These stakes for actual people are what make the government's interests compelling in the first place. So we frame these balancing analyses as if the rights of actual people are on one side, whereas nothing more than the interests of some amorphous abstraction called the state are on the other, when in fact it is the compelling interests of some people on one side and the compelling interests of other people on the other side. Which of these compelling interests are conventionally labeled rights and which are simply labeled compelling interests has more to do with legal pedigree and the evolution of rights talk than the actual gravity or importance of the interests on either side. So, can we break free of these conceptual blinders or breaks? I think possibly yes, and this particular right is very promising. How is it simultaneously familiar and disruptive? How might it potentially serve as a bridge to a post-liberal constitutionalism? Okay, so this idea of a right to effective government is perhaps obviously at odds with classical liberalism in several ways. First, at a normative level, the viability of a right to effective government turns on first order principles and beliefs about the nature and purpose of the state, or more simply the ideology of the state, that are difficult to reconcile with traditional liberalism, right? From a traditional liberal perspective, classical liberal perspective, the state is a necessary evil, the state that governs best governs least, and we should be skeptical or even hostile to the very idea of collective goals. And from this perspective, it becomes difficult to argue for a right to effective government. A state that can't tie its own shoelaces becomes affirmatively desirable, right? The night watchman state. But if the state has any legitimate ends, any legitimate collective ends, which it clearly does in a modern, interdependent, specialized economy, then any affirmative raison d'etre, then a constitutional imperative of effective government seems inescapable. If there's an end, there has to be a means, and the means is going to be the state. Ineffective government means that the government is failing to fulfill the purpose for its existence, the very reasons for which it's constituted. At a practical level, this right to effective government is also post-liberal in the sense that it's not just another right, but it's a condition to the fulfillment of other rights, right? Hannah Arendt famously described citizenship as the right to have rights. Much the same could be said of the right to effective government. No less than citizenship, this REG, I'll call it, is a master right. It's a right to have rights in several sense. A government incapable of acting effectively is a government incapable of fulfilling a right to health or education or a healthy environment or so on. Now, the continuing association of constitutionalism and liberalism doesn't completely get in the way of a move to a post-liberal understanding of constitutionalism that includes this REG concept. It does suggest, though, that post-liberal constitutionalism is more likely to emerge and stick if it is the product of evolutionary development rather than a revolutionary break. And this REG concept may be an ideal vehicle for that kind of evolutionary move. It simultaneously possesses and subverts certain trappings of liberal constitutionalism. We might think of it as a wolf in sheep's clothing or Trojan horse. I just want to touch on two of the moves that resonate with, but also put a twist on liberal constitutionalism. First, it employs, but also subverts the language of rights. And second, it employs and even elevates the idea of checks and balances. Okay, so on this idea of REG being a cornerstone of a post-liberal language of rights, Obviously, it invokes the language of rights, and in some sense, it might seem to fit existing typologies of liberal and post-liberal rights. It might seem to belong in the positive rights category in the sense that it is a claim or entitlement to something. But in another sense, though, it disrupts the existing categories in a way that positive rights don't, because it collapses the traditional distinction between rights and structure in constitutional thinking. It turns the structure of government into an end in and of itself, rather than simply a means to an end. Consequently, some new term or category is probably required for the right to effective government. We might call it a structural or institutional right. And then second, the way in which the right to effective government moves us to a post-liberal conception of checks and balances. On its face, it might seem to lack any obvious connection to the idea of checks and balances. The idea would seem to prescribe the opposite, in the sense that the idea is not to have government institutions limit each other, but rather to guarantee the efficacy of the government as a whole. The problem, though, with a major problem with the traditional liberal understanding of checks and balances is that state power is increasingly obviously not the only concentration of power upon which we need some check. The lived experience of liberal democracy underlines the dangers posed by unchecked concentrations of private power. Oligarchs, corporations, et cetera, wield as weapons the constitutional rights that were intended to protect, presumably, weak and defenseless individuals from the leviathan of the state. And so, this economic power, not only unchecked, but amplified by the constitutional framework that restrains public power, gives our oligarchs, our plutocrats, the power to sway elections. So the domain of politics is a potential counterbalance to oligarchy. The public leviathan could be a check on the private leviathan because it is the domain in which persons are, at least in some sense, guaranteed equality. By design, the restraints imposed on the state by liberal constitutionalism render this a lopsided contest and placed a heavy hand on the scales in favor of the private over the public. A right to effective government is nothing less than a right to a government capable of making and asserting decisions on the part of the people against the oligarchs and the plutocrats. What experience teaches us is that there's a need for checks and balances, not only among institutions of public power, but also between public and private power. And if you have an effective government, then you have a check on private power. Okay, I've gone a little over, but there's a lot to terrain to cover here. It's an intellectually rich book, and I hope I've done at least some of the themes justice.
Okay, thank you. Jerry, you'll challenge, I think, David's position.
Thank you. Some things I don't want to challenge. I agree that the subject of effective governance is very important, and that the exploration of the subject in this book is very valuable. Nonetheless, my role on the panel, as it was in the book, is to be cautious about the idea of a constitutional right to effective governance. I'm inclined to favor effective governance, depending on what that means. And I am in favor of affirmative constitutional obligations of the state to protect people's rights and to provide government services essential to their well-being. I regard the view that the U.S. Constitution imposes no obligation on federal and state governments to protect individuals against abuse of private power as reflecting a deeply regrettable philosophy of government. But is a right to effective governance the appropriate solution? What would effective governance mean? The phrase has a neutral instrumental sound that could appeal to people holding a wide range of values. That may be the Trojan horse that Professor Law referred to. To some of the authors in the book, it seems to imply rights to education, housing, food, health, employment, and protection against domestic violence. These are also themes of international human rights treaties, which not only list rights, but oblige states to respect, protect, and if necessary, fulfill them. Human rights are to be effective. To Professor Law, effective governance involves a commitment to a post-liberal, activist, and protective state. But to others, it has meant cost-efficient, non-corrupt enforcement of contract and property rights. The term good governance has been a vehicle of neoliberal financial power in the recent past. And to a literalist, effective governance may mean a strict obligation to enforce whatever laws are on the books. Assuming that the right to effective governance adds content beyond what the international human rights law already covers, would that entail disadvantages? Putting aside the standard objections to judicial activism and putting aside ad hominem remarks about the current Supreme Court, there are several grounds for concern. Once untethered from human rights, the right to effective governance may be drained of normative content. Recognizing a value-neutral obligation of effective governance could mean that beneficiaries of bad legislation and bad regulation have rights to insist on the effective enforcement of the laws as written. I'm sure that everyone in the audience can think of their own examples. The illustration that comes immediately to my mind is the Attorney General of Texas suing for ruthless enforcement of immigration statutes. If he can't do that in his official capacity under a right to effective governance because the state of Texas is not a rights holder, then maybe he can do it in his private capacity. Enforcement of bad policies has troubling consequences both because the policies are bad and because their enforcement competes for resources with the enforcement of good policies. And in conflicts between bad laws and human rights, the constitutional right to effective governance may add weight in the balance in favor of the bad laws. Another concern relates to questions of standing and court access. Who will be empowered to complain of non-compliance with the right to effective governance? And how early in the period before their own material circumstances are specifically affected? The more the right can be asserted generally by citizens, the more it may become a tool for ideological plaintiffs to redirect government policy. Next, who will have the resources and incentives to bring such complaints? And how will that determine which laws get effectively enforced? The right to effective governance sounds like a comprehensive right to wholesale effective governance. But if it is going to be litigated, it will presumably be litigated retail. A court will examine a particular law or a particular group of interrelated laws, and perhaps only as they affect the litigants before it. Studies have shown the tendency of individualized constitutional litigation over social rights to disproportionately assist middle and upper class groups rather than those in greater need. Moreover, do corporations also hold the right to effective governance? When it is put in comparative constitutional law terms, rather than in human rights law terms, it seems like an abstractly worded version of the right would be interpreted as including corporations as rights holders. That interpretation would also skew the consequences of recognizing the right. Corporations, more than human beings, have the money and the incentives and the expertise and the opportunities as repeat players to make long-term strategic use of litigation as a means to shape the legal environment that affects them. For these reasons, I am concerned that adding a right to effective governance compared to the protections that human rights law envisions would be a net detriment rather than a net benefit. If we want government to protect economic and social rights against neglect and corporate abuse, then we would probably do better by enshrining those rights explicitly, rather than hoping that a right to effective governance would lead indirectly to their protection. Now, perhaps these are arguments against a right to effective governance. Perhaps they are warnings about making an obligation of effective governance an enforceable individual right. Perhaps they are warnings for how a right to effective governance should be drafted so that it does more good than harm. But either way, I think they are serious concerns. Thank you.
Thank you very much. Because Professor Law has to leave, I think we should take a few minutes for audience questions and interchange about this particular issue, topic. So if someone has a question, comment?
Yes, hello. Can everyone hear me okay? For Professor Tushnet, we do have a couple questions through the Zoom virtual attendees. So we will address those first because they were submitted first, if that's all right. So our first question from a Zoom attendee. What is effective government and how is effective government defined and by what metric? Is it a legal metric or ethical metric, something else?
Okay, so David, I think you probably should address that.
Yeah, that's a good question. I think there would be metrics for effective government. I'm thinking the political science literature, actually, this is not something that I see much in the political economy or poli-sci literature. I think that there would be certain overt things that we would not want to see, which would be, the routinization and celebration of, even obstruction can be healthy. It may be the kind of thing where one has to look at the satisfaction of first order needs and the extent to which government is succeeding or not succeeding at those things. Now, the relationship between the satisfaction of first order needs and the structure of government can be difficult to establish in any traditional empirical social science way, but it's something that people clearly experience, and it's the basis on which people vote in reality, right? Or even if they don't vote, we know that the support for government in authoritarian and semi-authoritarian regimes has a lot to do with the ability of governments to bring home the bacon, deliver the goods. So it may be that the best starting point for this is actually public perception.
Jared, do you want to say something? I actually have a comment I could make. But,
Please do.
So one possibility would be to measure something like what I would call and will call government capacity by measures like number of service deliverers per capita with respect to some first order interest, or number of police officers, or the degree to which there's I would say corruption, but leakage from the allocated resources to particular enterprises. The less leakage there is, the greater the effectiveness of the governance. And there are lots of measures of corruption rattling around there.
Thank you. We have another question from a virtual attendee. What enforcement mechanism is being considered, notwithstanding vote turnout, is decreasing, ascribed to a variety of reasons? Don't care, suppression.
Yeah.
I'm not sure I understand the questions.
Could you repeat?
So the question one more time. What enforcement mechanism is being considered, notwithstanding vote turnout, is decreasing, ascribed to a variety of reasons? Don't care, suppression, ...
Okay, so I take the question to be, in part, maybe directed to Professor Jackson, if it's not a justiciable right, and there's decreasing popular participation in voting, how is the right to effective governance going to be enforced?
So is this thing on? So I will just say that I worry that U.S. constitutional discourse is overly dependent on the identification of judicial remedies, that it saps vitality from the idea of what our constitutional principles are, to assume that only a judicial remedy can vindicate them. Now, the question embraced voting. And voting is another kind of remedy and accountability. And do we have enough voter turnout? Probably not. I don't see the US in the near future going to the Australian mandatory voting system, but that is one possibility. But another possibility is, what do we talk about? What is it that you expect your representative to do once you've elected somebody? And talking about and evaluating that. So discourse is a very soft kind of approach, but I think it has been overlooked, and it's one of the areas. And there are other things we could also talk about, but I want to move on to the rest of the panel.
Okay, so thank you very much. If people have questions about this, there'll be another round of Q&A after the next two panel presentations. But we'll start with Professor Dawood. Renew with Professor Dawood.
Well, it's wonderful to be here today, and I'd like to start by thanking the Harvard Law School Library for putting on this fantastic event, this book panel. It's been absolutely wonderful working with Vicki Jackson on this book and with all of our terrific contributors. This is very much a pandemic project, and so I'm really grateful that we have this opportunity to be together to discuss some of the ideas of the book. So in my essay for the volume, I focus on the question of the relationship between effective government and constitutionalism. And my essay is motivated by the following puzzle. So certain governments, such as authoritarian regimes with robust economies, are effective, but they guarantee little in the way of what we traditionally understand as constitutionalism in terms of constitutional rights or a government hemmed by law. Other governments, say for instance democracies with weak economies and negligible public services, may protect constitutional rights, but they're lacking in governmental efficacy. So I explore the following questions in a preliminary fashion. First, does effective government require constitutionalism for its functioning? And conversely, second, does constitutionalism depend upon effective government to secure its protections? So a threshold issue which was already raised in the Q&A is, how do we define effective government? So I'm going to suggest that a minimalist approach to defining effective government would say that an effective government is one that meets the needs of society by appropriately managing public resources and public affairs. And we could identify a number of markers such as a robust economy, little or no poverty, widespread education, full employment, and that sort of thing. Now, this minimalist approach to defining effective government can be contrasted to a thicker conception that would include key democratic ideals such as citizen participation, responsiveness to constituents, deliberation, and the like. And on this view, you cannot have effective government unless it's democratically responsive to citizens. And in fact, in the volume, Professor Katerina Pistor observes that we can distinguish effective government from effective self-governance. So all this to say that I think effectiveness may mean different things. So taking these different meanings into account and going back to the two questions I started with, my essay makes 3 points. First, I suggest that there are in fact two functions of constitutionalism. So constitutionalism is conventionally understood as government that's limited by law through such mechanisms as constitutional rights, the separation of powers, federalism, and so on. Yet constitutionalism arguably has a second function, which is to establish the institutions and processes that are required for effective government. So drawing on the political thought of the founding era of the US Constitution, I show that constitutionalism not only applies to legal constraints on the power of government through a variety of legal mechanisms, it also defines and establishes the institutions through which such power is generated and wielded. So this suggests that the concept of constitutionalism contains within it a commitment to effective government. And this is in line with the work of scholars including Vicki Jackson, Nick Barber, and Turku Useksel, who've argued that there are important connections between constitutionalism and effective government. So I suggest that a focus on these two faces of constitutionalism, power generating and power limiting, shed fresh light on the relationship between effective government and constitutionalism. My second point is that although these two concepts are conceptually linked, the relationship is actually quite complex. So to capture this complexity, what I do is I set out a topology consisting of four possibilities: effective government and constitutional rights, effective government without rights, ineffective government with rights, and effective government versus rights. Now, although I'm focusing on constitutional rights, I also consider the role of constitutionalist structures more generally. Now, I won't get into the details because of time constraints, but I will offer a few preliminary observations. So first of all, taking authoritarian regimes. Effective government in authoritarian regimes is usually dependent upon constitutionalism in its power-generating sense, but often takes place in the absence of constitutionalism in its power-limiting sense. By contrast, in democratic nations, rights can help to protect and indeed may be indispensable for effective government. At the same time, a minimum level of effective government is required to secure rights. So to illustrate this last point, it's useful to consider the right to vote, always a good thing to do on election day. So in democracies, a basic requirement of effective government is to provide the right to vote and the institutions and processes needed for free and fair elections. But by the same token, the availability of regular, open, and competitive elections supported by electoral and participatory rights can strengthen the accountability and functioning of democratic government. So taken together, these observations suggest, at least with respect to democracies, that constitutionalism is dependent to some degree on effective government to secure its protections, and conversely, that effective government requires constitutionalism to some degree for its functioning. Now, on this last point, the some degree, is it the case that for effective government, the Constitution matters that much? So how much, for example, does the US Constitution matter when it comes to effective government? Do different constitutions, different constitutional arrangements change whether or not we have effective government? So this is a really hard question. My sense is that the availability of constitutionalist structures is not wholly determinative of the effectiveness of democratic government. So we see, for example, in this country, that governmental effectiveness changes over time. Sometimes it's worse, sometimes it's better. So I claim instead that it's actually the interaction of various factors: constitutional, political, institutional, and civic factors taken together that produces effective government. So to put it another way, constitutionalism is a minimally necessary but not sufficient condition for effective democratic governance. So finally, in conclusion, I think this is a particularly important time to be thinking about the connections between constitutionalism and effective government. As was mentioned earlier, nations around the world are facing a crisis of effective government, but ineffective government can also sometimes pave the way for authoritarian regimes to take hold in democracies. So in their bid for power, autocratic leaders have often capitalized on citizens' disenchantment with governance failures. So it seems to me that the sustainability of democracy must take into account effective democratic governance. Thank you so much.
Thank you. So I'm going to start out with a narrow idea, I think it's a narrow idea, that will ultimately connect with the themes that Professor Dawood has just articulated. The chapter that I co-authored with Madhav Khosla deals with the ways in which courts can contribute to building the capacity of governments to exercise power effectively. We have a number of case studies. I'm going to mention only two of them because of time limits. So the first mechanism by which courts can build capacity or assist in building capacity is sort of obvious, which is that their decisions can provide incentives to the existing mal or under-functioning government to improve its functioning. We use, and that's sort of straightforward, if you think about imposing liability on a government agency for failing to perform or failing to meet constitutional standards in some dimension, then it will have an incentive to clean up its act. But we use, I think, some ways more interesting example than the standard ones, which are the mostly Latin American right to medication cases, which begin by litigants. Professor Neuman mentioned some of the studies of this, litigants seeking a constitutional guarantee. They have a constitutional guarantee to medications or health or something like that. They seek medication that's not on the approved list for what's supplied by the government or its insurance systems. And for a variety of reasons, many courts, including constitutional courts, endorse the idea that if your life is threatened and there's some prospect that this unapproved medication will preserve or extend your life, then you have a constitutional entitlement to that medication. So these cases begin with lots of individuals making these claims, but it turns out that's a crazy system because you end up with unsystematic demands being made on the health ministry. And the way to solve the problem is to improve the system by which medications get included on the approved list. And most of the systems that have faced these cases, again, start out with these individual claims and end up with this kind of bureaucratic capacity building. That is the component of the Ministry of Health aimed at generating the list starts to do a better job in generating the list. And then courts say, well, the fact that it's not on the list no longer tells us that the government's somehow misbehaving. And so we're going to let them, we're not going to award the individualized claim. Okay. The second example is something that I have in my notes as the courts acknowledging innovative exercises of power while simultaneously limiting those exercises. And the key point is the innovative exercise of power. We use a case study of the Indian system of personal identification for the receipt of social welfare benefits and voting, it turns out. Basically, it's called the Aadhaar system, and it's a biometric system of identification. And the nominal justification for it, and probably a significant part of the justification, was avoiding corruption, ensuring that people who are entitled to the benefits get them, and that people who aren't entitled to them don't get them, and that the bureaucrats distributing this stuff distribute it to the right people. So there is an effective governance component of this, but people were in India quite concerned about the fact that the government would have all this information about them. And there was a large political controversy over this system. And what the court did was to say, well, look, we're going to allow you to go ahead with this biometric system, but you can't link the identifications across, across institutions. If it's the food distribution agency, they can't give the information they're getting to, in particular, banks. That was the main issue. They didn't want information flowing across banks. And that seems to make an appropriate adjustment of the, again, this biometric system. And here's where I want to connect up with the themes that Professor Dawood just mentioned. If you look up on the internet, look for definitions of constitutionalism, I think it's sort of massively dominated by a quotation, I think it's from Charles McIlwain, which defines constitutionalism as a system in which the power of government is limited, that its limitation is built into the definition of constitutionalism, and as Professor Dawood suggests, without noting that the predicate is that there's a government there to be limited. Well, there's a body of literature that says, you know, one thing that limitations on government power can do is actually enhance government power. If you tell the government, or if the government is not able to do some things, like appropriate the wealth of the barons, then it may be able to do other things, like raise an army to defend against foreign threats. This is a theme in work by Barry Weingast and Douglas North and Stephen Holmes. And there you see constitutionalism as a system of simultaneously limiting power for the purpose of enhancing it. And that, I want to conclude, connects up to a theme suggested by Professor Jackson's mention of the presidential power issue in Chadha. So consider discussions of a unitary executive versus a plural executive in the United States. So unitariness is defended on, as against a plural executive, on two grounds. One is liberty promoting, and that's the theme in the most of the recent cases about the unitary executive, and it is liberty promoting. If you have a unitary executive, you know who it is who is abusing constitutional rights. If you have a plural executive, it can be, responsibility can be diffused. But actually, when you look at what the Federalist paper says, the primary thing about the unitary executive is that it is a way of ensuring energy in the executive, allowing, creating an executive that will actually be able to carry out the functions of governance that are committed to it by the Constitution. And so, just to wrap up, I think, you know, one of the themes in this conversation is the relationship between effective governance and the protection of rights. And I think the suggestion that we're getting from all of the comments, and is, I think, present in many of the contributions to the book, is that these are not separate phenomena. That is, empowering government and protecting rights are, to use a term from another part of constitutional here, co-constitutive. They occur simultaneously, and I don't know what I have this image of Buckminster Fuller's, you know, whatever they're called. They support each other in an interesting tension. Thank you. Okay, so we have 5 minutes, that's right, for comments. Are there?
Yes, thank you so much for sharing your insight. So if you're joining us in person, I see some hands raised already. That's great. Please raise your hand and we'll do our best to come around and take your questions. We also have another virtual question that was submitted. We're going to answer that first because it was submitted first, and then we'll move into some of these in-person questions. So from a virtual attendee, one can talk about effective government, but following agreed metrics and yet failure to comply is expressed. What is the remedy? Vote out the miscreants, meet the new boss same as the old boss, won't get fooled again. So that is from a Zoom panelist, or a Zoom attendee.
Yeah. So that's a really serious problem. And I think Professor Neuman suggested some difficulties with it. I just would want to note that for myself, I would focus on improving what I would characterize as bureaucratic capacity, making sure that the agencies who are tasked with delivering the goods actually do so. And that involves anti-corruption activities and professionalization of the bureaucracy and civil service guarantees and a whole range of things like that, which are, they come under the heading of good governance and probably are mostly cultural accomplishments rather than enforceable either by courts or as legislative directives. Yeah, so let's, yeah. Okay.
No, that's fine. I'll just start it. So it's a question in two parts. The first part is, I know Professor Tushnet has done a lot of work on fourth branch institutions, some of which play these roles because in your structural logic, the three traditional branches don't always compete with each other and hold each other to account, and therefore there is a loss of effectiveness. So I'm wondering whether this idea of right to effective governance provides some, I suppose, rights-based conceptual justification, additional justification for having other branches because they ensure, for instance, elimination of corruption, electoral integrity. That's one. But the second one, I was just thinking as the conversation played out, that we talk a lot about holding government to account, but when I think about crises in effective governance, especially in the US context, sometimes you have to hold the opposition to account. So whenever a debt ceiling issue comes up, the opposition blocks anything from happening and causes things to stop. Or in other jurisdictions, you would have a kingmaker type political party that just refuses to cooperate and that delays COVID relief and things like that. Is there any scheme in which, or any of your papers address, where the oppositions also have a responsibility to contribute to effective governance?
So I'll say something about actually both of those. Just on the fourth branch issues, yes, I mean, clearly they are in part aimed at these kinds of concerns, but one of the themes of my book, which was, I want to say, expressly tentative and preliminary, was that the design issues for these institutions are really difficult. And it's very easy to overclaim about what they actually can accomplish, even if well designed, and designing them is very difficult. On the role of the opposition, so I have two thoughts. One is that maybe the role of the opposition is appropriately defined by norms, or what Levitsky and Ziblatt call guardrails. But the other is that there are some mechanisms in some constitutions that David Fontana has written about of actually granting power to the opposition as a way of both checking the government, but also ensuring that the opposition sees itself as part of the governing process rather than outside it.
And if I could just add one word, part of my project elsewhere on norms has to do with developing the idea of what it means to be an elected representative, whether in the majority or in the opposition. I've spent a lot of time thinking about the normalization in the United States of shutting down the government, which it strikes me should be words that should never pass the lips of an elected representative. We want government to do things. And so one project is to try and think in legal education, what would we say are the obligations of representatives? We talk about the obligations of judges, but there's another conversation to be had.
There was someone in back? Yeah.
Sam.
Oh, okay, Sam, and then in back.
Sure. So one of the things that really struck me while watching this panel is the level of disagreement around the term effective government. And I think, Professor Dawood, you talked about different conceptions existing within that framework. And it struck me that that's actually quite a potentially productive and helpful contestation to have that. So my question is, constitutionalizing a framework like effective government, to what extent does that assist, I guess, the helpfulness around contestation, or to what extent does it ossify or judicialize or that kind of healthy contestation?
So I think the problem with effective government as a concept is that it could be completely compatible with a terrible regime, right? And I think that's the point that you're shedding light on. And so that is why putting a substantive, element to it would make a lot of sense. So effective self-governance. That doesn't necessarily answer all the questions, though, right, in terms of ossification, because you could imagine that even if we have those substantive limitations, it could eventually, if it's constitutionalized, become difficult to get, or it could be misused in some way. So I completely appreciate the problem. I'm not sure that I've got an answer, except to say that you'd have to be very careful about how you would define it.
And then in back,
I think Sandy also has a question.
And then maybe we'll get to Sandy.
Sandy.
Thank you. Can you hear me?
yes.
Yes. So to me, it would seem that the element that's missing is effective citizenship. Because if you're talking about a constitutional government that in its wording limits government, it really would therefore require a more effective citizenship. And the other thing is when the private sector becomes so large and powerful that the citizen has no rights really and effectiveness, it seems like all around it's the lack of citizenship effectiveness that underlies a lot of the problems.
Yeah, here, I again revert to the Federalist Papers. In one of them, I think in Madison says, look, the solution to all of our problems would be if the citizenry were virtuous. That would be great. But I can't figure out how we can guarantee that'll happen. And there's a sort of a lot of writing about institutionalizing mechanisms to ensure virtuous citizenry, and it's messy and difficult to guarantee. And so all these things are, in some sense, second best solutions, if they are. But yeah, the first best is virtue, civic virtue. And that's sort of generally agreed. Jerry, do you want to say something?
Yes, I'd like to say something in response to this question and in response to the previous question from Sam Bookman. Although, of course, I'll be speaking from my role here as the skeptic, which is to say I see a very serious chicken and the egg problem here, particularly if we're talking about a divided society like the United States. If we want to talk about effective government, we want to say effective about doing what? The fact that full employment is not a constitutionally imposed right or goal in the U.S. Constitution isn't going to be cured by adding a right to effective governance unless it's somehow written into the text of the effective governance clause that it's going to serve all these goals that people have been complaining have not otherwise been found in the Constitution. And if there's that much disagreement about values and policies in the society, it's not clear what the common minimum standard is by which to measure whether a government's effective. You know, if GDP is huge and people are sleeping on the streets, for some people that's a demonstration of ineffective governance, and for some people that's a demonstration of effective governance.
Okay, so I think we have to wrap up.
Yes, at this time, I'm sorry, yes, we do have to wrap up. We want to thank our esteemed speakers for this wonderful conversation.